Welcome to the panel for the discussion, Is it time to end life tenure for federal judges? A topic for which I hope the presumption against retroactivity applies. The framers of our Constitution jealously guarded the independence of federal judges, and the principal means they selected for doing so was to confer life tenure upon them. But a great deal has changed since then. At the founding, federal judges were not alone. Most state judges enjoyed life tenure as well. But now federal judges are almost entirely alone, not only in the United States, but in the world. Life expectancies are longer today than they were, of course, 200 years ago. And some say the process for selecting federal judges has become more political. Imagine. Recent polls show that over 75% of Americans want to end life tenure. Is it time to end life tenure? Are there ways to end it that do not require a constitutional amendment? Our panelists will debate these questions. I'm going to introduce each of our panelists. The Federalist Society, of course, is assembled as always, an all-star panel for the discussion of this topic. I'm going to introduce them in the order in which they will speak. Each of them will have 6 to 8 minutes within which to give opening presentations. We'll have then some discussion among them, perhaps some questions from their moderator, and then we'll open it up to questions from the audience. Our first speaker will be James Pfander, who is the Owen L. Kuhn Professor of Law at Northwestern University Pritzker School of Law. His teaching and research focuses on the role of the federal judiciary, and his latest book is Constitutional Torts and the War on Terror. A member of the American Law Institute, Professor Pfander recently concluded his work as a reporter consultant to the Federal State Jurisdiction Committee of the Judicial Conference of the United States. He has served as chair of both the federal courts and civil procedure sections of the Association of American Law Schools. Norman Ornstein is a resident scholar at the American Enterprise Institute, where he studies politics, elections, and Congress. He is a co-host of the Institute's Election Watch series, a contributing editor and columnist for National Journal and The Atlantic, a BBC News election analyst, and the chairman of the Campaign Legal Center. Dr. Ornstein previously served as co-director of the AEI Brookings Elections Reform Project and senior counselor to the Continuity of Government Commission. He is a fellow of the American Academy of Arts and Sciences. David Trask is a judge of the United States Court of Appeals for the Eighth Circuit. Before serving on the Eighth Circuit, Judge Trask was an associate justice of the Minnesota Supreme Court. Before he became a judge, he was a member of the faculty of the University of Minnesota Law School. You know, in football, we used to call it Minnehaha, but now they actually can play it. There, he taught and wrote in areas of federal courts and jurisdiction, constitutional law, criminal law, and politics. Judge Trask served as a law clerk to Justice Clarence Thomas on the Supreme Court of the United States. Stuart Taylor is a Washington writer focusing on legal and policy issues and a National Journal contributing editor. He occasionally practices law. Taylor has co-authored 3 books. All have been acclaimed by commentators across the ideological spectrum. Since 1980, he has done reporting and commentary about issues ranging from the biggest Supreme Court cases to race, voting rights, excessive criminal penalties, campus rape processes, journalistic bias, war powers, guns, civil liberties, education, impeachment, and other issues. He's often been called one of the nation's best legal journalists and is known for challenging both liberal and conservative conventional wisdom. Carrie Campbell-Severino is the Chief Counsel and Policy Director of the Judicial Crisis Network and co-author with Molly Hemingway of the best-selling book, Justice on Trial, The Kavanaugh Confirmation and the Future of the Court. She writes and speaks on a wide range of judicial issues, including the constitutional limits on government, the federal nomination process, and state judicial selection. Ms. Severino also served as a law clerk to Justice Thomas on the Supreme Court. So, without further ado, Professor Fander.
Thank you, Judge. Much of my work, come through, no? Much of my work on the independence of the federal judiciary focuses on questions separate from life tenure. I've taken tenure during good behavior as a given in thinking about the Article III judiciary, and have asked questions about the other provisions of the Constitution that secure an independent judiciary. These additional safeguards of independence strike me as worth briefly sketching as a prelude to the panel's more focused assessment of life tenure itself. So let's catalog the protections of judicial independence in the Constitution and place them in historical context. Article 3, as you know, vests the judicial power in one Supreme Court, and such inferior courts as Congress shall, from time to time, ordain and establish. It provides that the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. It's the good behavior clause, needless to say, that confers life tenure. Additional protections appear elsewhere. Article 2 provides for presidential nomination and appointment, as we all know, and the impeachment clauses in Article 1 and Article 2, much on our minds these days, provide for the removal of judges on impeachment and conviction of high crimes and misdemeanors. So, bracketing for now the good behavior provision, I want to talk about the other provisions of the Constitution that help ensure judicial independence. So first, the provision for the payment of a compensation for judicial services not diminished during their continuance in office. Second, the protections of independence entailed in the provisions for judicial removal from office. And then finally, and in some ways I think most important, we have the guarantee of independence that flows from the vesting of the entire judicial power in the Article 3 judiciary, the provision for one Supreme Court to superintend the work of inferior courts. So first, the assurance of compensation free from diminution. It surely helps protect the judiciary from retaliation, but it also introduces a one-way ratchet. Congress can raise judicial salaries but can't lower them, and that means as a practical matter that judicial salaries will tend to lag. Happily, though, despite the best efforts of James Madison, Article 3 doesn't include a provision that bars any increase in judicial salaries. The framers knew about inflation and they understood that judges' salaries would need adjustments, so they eliminated a provision that would have barred any increase. And I'm sure my judicial colleagues will be happy to know that the framers rejected a provision that would have hedged against inflation by calibrating judicial office salaries in terms of such commodities as wheat or tobacco. Apart from calling for the payment of salaries, the framers also appear to have ruled out the payment of fees. This was an important structural choice. It made compensation by way of salary a fixed feature of the judge's package and ended the practice that was common in the colonies and in England of paying judges in part through the fees paid by litigants in the course of litigation. Superior Court judges in England earned an enormous amount of money from the payment of litigant fees and the sale of judicial office. By putting federal judges on salary, the framers tended to encourage the federal judiciary to respect the boundaries that had been assigned in the Constitution and to reject new assignments of work instead of reaching out for new cases that would bring in new fees. In other words, the framers wanted the judges to shirk. Another source of judicial income was also foreclosed, and that's the sale of offices. That often meant the creation of sinecures in England, underwritten by litigant fees. Article 2 of the Constitution specifies that any appointments of inferior officers were to be made by the courts of law as courts and not by the judges within those courts. So when Chief Justice John Jay was first appointed Chief Justice of the United States, he steadfastly refused applications for patronage appointments, explaining that all appointments were to be made by the court itself. By making salary the only source of compensation, the power of the political branches to curtail compensation, either through the adjustment of fees or the curtailment of offices for sale, was thereby eliminated. Judicial removal. Next, the provision of independence provided for in the provisions for removal for office, Some have argued that it would be permissible for Congress to create a mechanism for the removal of federal judges outside of the impeachment and removal provisions by empowering the courts to adjudicate scire facias claims to curtail access to judicial office for misbehavior. And without belaboring the point, I think there's very little evidence to support that claim, either in the Constitution itself or in the history that led up to it. The Constitution tends to create judicial tenure and other office tenures, and also to provide a specific way to curtail that tenure. That's true of members of Congress, it's true of the president and the vice president, and it seems to be true of judges as well. Other forms of removal were considered at the Philadelphia Convention, such as removal upon the address of the legislature, but Gouverneur Morris and others argued against address. They argued it was unfair because it would deny judges a trial on the merits before the Senate in a determination of whether the judge should be removed from office. And the framers were obviously worried about cabals and secret agreements in cloakrooms and understood that problem as one that required a trial in open air. So for these reasons, I find it difficult to believe that the framers meant to leave Congress free to specify judicial removal through any proceedings other than impeachment and conviction. One Supreme Court. The provisions of Article 3 that vest all the judicial power in the federal courts and establish one Supreme Court to supervise the whole judicial structure establish important protections for independence. By requiring supremacy and making other federal courts inferior to the Supreme Court, the framers barred Congress and the President from acting either alone or together to set up new courts and vest new or alternative forms of judicial power in them. Congress can provide for new courts and the President can staff those courts, but they all have to answer to the Supreme Court of the United States. Which brings us in a roundabout way back to the problem of life tenure. Congress has created and the President has staffed a host of federal courts that employ judges lacking life tenure. When one considers administrative law judges, bankruptcy judges, magistrates, military judges, we have an untenured federal judiciary that dwarfs the size of the Article 3 judiciary. So if we say there are roughly 900 federal Article 3 judges, we could compare that number to 1,900 ALJs, 350 bankruptcy judges, 540 magistrate judges, and several military appellate court judges. We have, in short, accepted a substantial curtailment of life tenure by creating judicial offices for judges who lack Article 3 protections. But we make our peace with these non-Article 3 judges by making sure their judicial work remains subject to the oversight and control of the Article 3 judiciary. In other words, we accept a measure of non-Article 3 control at the bottom end of the judicial hierarchy, but we've so far declined to accept anything less than tenure during good behavior at the top. So now my colleagues will let us know if it's time for the top to change. Judge.
Thank you. Dr. Weinstein.
Thanks, Judge Pryor. So I've been an advocate of term limits for Supreme Court justices for more than 20 years. And I just want to lay out 3 reasons why and talk about what I would like to do, which would be single 18-year terms staggered so that for every presidential term there would be an opportunity to fill 2 vacancies. So 3 reasons. The first, and it really began to build on me more than 2 decades ago, that the temperature obviously was rising every time there was a vacancy in the Supreme Court. Same has been true at other levels, and particularly the appeals court level, but more for the Supreme Court. the court is now making more and more decisions, policy decisions that affect the daily lives of Americans. We're seeing in a tribal and polarized atmosphere the sense that the consequences of these decisions are much, much greater. And while moving to a single 18-year term, and I will say I came upon that in part because of the 9 justices, but also because we've seen this work before. The Comptroller General of the United States fills a single 18-year term. And if you talk to any of those who have been Comptroller General, they will tell you that it is a long enough time for them to be able to accomplish goals, but that it has preserved a significant amount of independence for them as well. And it would, I think, make a difference. The second is I'd like to remove the actuarial game that we have here. The idea that a president in a term might be able to fill 4 vacancies for the court and another president none. And given that people can serve on the court for 30, 40, 50 years or more, long after those presidents have left office, the idea of creating a better balance also, I believe, would add to the legitimacy of the choices and of the court. And thirdly, I want to broaden the pool of those who would be considered seriously for a position on the Supreme Court. Of course, the framers really thought that a tenure in good behavior or life tenure was required because giving people that salary for life would encourage those who would make very little in the legal profession otherwise to be able to serve. But I think what's happened in recent decades is that because presidents want to have that power of an appointment to the Supreme Court for as long as they possibly can, we now look at those who are much younger and basically disqualify those who are older. And that was particularly striking to me when I saw what I believed was a reality that a judge who I thought would have been superbly qualified for the court, J. Harvey Wilkinson, basically, because he was 60, was pushed to the side so that they could move to people in their 40s and 50s. Here, given what we know about life expectancy, picking top quality people in their 60s would be feasible and maybe even desirable. Now, finally, I would just say I believe this can be done without a constitutional amendment. Service for good behavior in the judiciary doesn't mean necessarily that you are a Supreme Court justice. And one could move after 18 years to an appeals court, either an appeals court of the choice of the justice, or even by creating a special appeals court, or to senior status. You can preserve that constitutional requirement and do it, I think, without requiring a new constitutional amendment. Now, I've thought about whether we wanted to apply term limits to other levels of judges, not retroactively. It becomes a little bit more complicated. What I'd like to do is to see this done at the Supreme Court level, see how it works, and then get a discussion going about whether it would be something that would be applicable and desirable for courts of appeals, for example. Thank you.
Thank you. Judge Trask.
So I'm the federal judge on the panel, other than our moderator, and you may not be surprised to hear that I'm here to defend life tenure. But let me just say at the outset that I sat on a panel similar to this at the Federalist Society Convention 10 years ago when the question of life tenure was part of a showcase panel, and I had the exact same view. Now, at that point, I think I did have tenure at the law school, but I wrote my article, my underlying article, before I had tenure anywhere. In any event, I want to quickly highlight the constitutional issues and then the policy issues. So, and I'm going to leave a little bit out. Hopefully, we can talk about it during questioning. I think that the combination of two provisions, two structural principles in the Constitution means that you cannot do this by a statute. You have to do it by a constitutional amendment if you were going to do it. The first is during good behavior. That language, we went back all the way to English common law, co-author of mine, Ryan Scott and I, went back to the English common law, and what we discovered was that's how they conveyed life estates at English common law. Now, the life estates were defeasible by whatever was laid out in the deed or in the conveyance instrument. And here, the life estate would be defeasible, but only by misbehavior. So I think it is absolutely clear that you have life tenure. Now, that doesn't fully answer the question. The second part of it is what I consider, or we have called, the separate offices reading. The Constitution creates 3 separate offices, judicial offices. There's obviously legislative and executive offices as well. You've got the Chief Justice of the United States, you've got the Supreme Court judges or judges of the Supreme Court, and you have the judges of the inferior courts. I think mixing and matching within those categories is fine, but I don't think you can move one judge from one category to another category without a new confirmation. For example, taken to its logical extreme, under the view given by those proponents of term limits by statute, you would be able to rotate the Chief Justice, okay? I don't think anyone is advocating for that. And you would be able to do it from the lower courts, or you would be able to do it from judges of the Supreme Court. So I think the separate offices reading means once you are confirmed to a particular office, that's it. You don't move them without a new confirmation hearing. Now, I want to quickly go to the policy arguments, which is something I wrote about almost 15 years ago. First of all, I don't think that the empirical case for term limits or other limitations on tenure is particularly strong. This is something where I was probably in the minority, but I don't think that the length of tenure, even on the Supreme Court, is completely out of line with what the framers envisioned. There's lots of evidence in the Federalist Papers and elsewhere, in the anti-Federalist Papers as well, that people fully contemplated lengthy tenures. Then there's the issue of strategic retirements, which means that there's a theory that some judges and justices retire so as to ensure a like-minded successor. The evidence for strategic retirement is even weaker empirically. There's anecdotal evidence all over the board, I admit that, but empirically, really nobody's been able to prove it. There was one political science article, I think, that came pretty close, but it was debunked later on by other empirical studies. And so while the anecdotal evidence is strong and there appears to be smoking guns, it's not all that strong in the end. Now, judicial independence. I think I'm in a little bit of a unique position here. As Judge Pryor pointed out, I served on a state Supreme Court for about 7 years. I ran statewide for office in a contested election, and now I have life tenure. I do think that there is value, a lot of value in life tenure. I think it enables judges to not have to listen to outside voices, to be able to decide the cases purely based on the law and to do the right thing. And that's not to say that serving in an election system did not allow judges to do that. I always called them like I saw them. When I was on the state Supreme Court, when I was 1 month away from election, I always viewed my job as doing the right thing and applying the law as written. But at the same time, I'm not sure that everybody else viewed it that way. And so I think that life tenure makes a difference. There's also various things that happen when you have a defined term. There's a final period problem, for example. When a justice is at year 16, perhaps they change their behavior knowing that they're going to need another job at year 18 when, if they're purely removed from office, or even under this, some people don't want to be moved to the lower courts, and so perhaps they decide at year 16 I changed my behavior because at year 18 I don't want to be rotated to a lower court. I want to be a member of the executive branch. There's famous examples of Supreme Court justices who left to take executive branch or legislative branch positions. So I think that's a problem. And finally, I want to make one last point. I've heard this argument for about 15 years now that somehow this will change confirmation hearings and make them less contentious. I think that is just plainly wrong. I think that is a pipe dream. And the reason is 18 years is way longer than the political horizon for any politician. So if you are a senator, you have a 6-year horizon. If you are the president, you have a 4 or 8 year horizon. Whether that justice serves for 18 years or for life, I don't think makes a lick of difference, and that confirmation hearings for Supreme Court justices under a term limit scheme will be just as contentious as they are now. And having gone through a contentious confirmation proceeding, I think I can say that with some degree of confidence.
All right, thank you. Mr. Taylor?
Thank you, Judge. These are hard acts to follow. I'm going to agree generally with Norm Ornstein and disagree respectfully with Judge Strass, except I'd like to begin by agreeing with you on confirmation hearings. In fact, I stress at the outset that the biggest problems with the federal courts will not be solved or even much eased by ending life tenure. The central problem, I think, is the sharp ideological polarization between the 5 Republican Supreme Court appointees and the 4 Democratic appointees. It would still be a problem if the 5 and the 4 were differently arranged. And it reflects the polarization of the country. I don't think tinkering with appointment with life tenure is going to change any of that. In an era when the justices have given themselves and lower court judges vastly more political power than was imagined by the framers, polarization puts them at risk of being seen not as neutral arbiters of equal justice under law, but as gladiators in an arena ruled by unprincipled partisan politics, president, company accepted, of course. Term limits seem most unlikely to ease any of that, or the ugly partisan brawls that Senate confirmation proceedings have become. Indeed, they would make such spectacles more frequent. I nonetheless feel strongly that it is time to end life tenure for Supreme Court justices, perhaps not for lower court federal judges. Most scholars think, and I agree, and as Judge Strass indicated, only a constitutional amendment could impose term limits on federal district and appellate court judges. Don't hold your breath for the constitutional amendment. But unlike Judge Strauss and many other scholars, I also think Congress should be able to limit the terms of future Supreme Court justices by ordinary legislation, provided that at the same time Congress also allows senior justices after expiration of their Supreme Court terms to participate for life in lower court cases. Judge Strass has made a very eloquent argument why this is wrong. I'm not going to grapple with that in detail in my limited time, but I do register a dissent. While ending life tenure for the 9 justices would not solve the biggest problem, it would ameliorate some other problems, I think. And as to what term limits for justices would look like, I'm generally in accord with Norm Ornstein's idea that 18-year fixed terms followed by the ability to continue on the lower courts would be about right, and it should be phased in so that every president gets 2 appointments, ideally in every term, to space it out so that you don't have the fluke of 4 appointments by this president, 0 appointments by the next president, and so forth. Paul Carrington, a Democrat and a professor, and Roger Crampton laid out in great detail how this would work, and it's pretty complicated. This was in an article they did in 2005, joined by about 40 other ideologically diverse law professors. If the 9 current, no, I'm sorry, I'll skip that. The arguments for term limits, which I'll focus on, are numerous and I think cumulatively quite powerful, apart from the legality of it. The broad objective would be to marry more frequent and regular injections of new blood with judicial independence, which can be protected, I think, without allowing justices to keep their vast powers for life. What are the problems with life tenure? Begin with the facts that no other advanced nation gives judges life tenure or seems to think it's necessary, with the fact that life expectancies have grown greatly since the 1700s, as Judge Pryor pointed out. In fact, the first 10 justices served an average of under 8 years each. And also in a recent poll, Marquette poll, 72% of respondents supported ending life tenure. Add to that the risk that some justices will remain on the court until mentally debilitated or at least past their prime, as did Justice William O. Douglas and some others in the past. After a stroke, Douglas barely functioned during the last 10 months of his record-setting, almost 37-year tenure. Justice Thurgood Marshall was a mere 83 years old, just 5 years older than Bernie Sanders is right now, when asked in 1991 why he was retiring. He answered, because I'm getting old and falling apart. That's a realization that showed wisdom on his part, but won't necessarily be shown by many others. The hazards of advanced age also include more rigid mindsets, losing touch with the temper of the times, and in such powerful positions, the kind of arrogance and hubris once seen in medieval monarchs. Life tenure also creates incentives for presidents to seek nominees young enough to serve 30 or 40 years. We've all seen this happening, and the J. Harvey Wilkinson example is a good illustration of what it costs us. Compare this contemporary convention with the fact that the 90 justices who had completed their terms by 1970 retired on average after 15 years on the bench at the age of 68. Life tenure raises the stakes of each nomination and makes confirmation battles even more ugly. It's hard to imagine them becoming much more ugly, but it's a problem. And attempts some justices to time their retirements for political advantage. Life tenure also limits the opportunities for new presidents and senators to inject a degree of indirect political accountability into the court. Then there's the ease with which aging justices can and have limited their workloads by hearing fewer cases, now about half as many as in the 1980s, and delegating work to law clerks. In this regard, the justices are unlike lower court judges, whose heavy caseloads create incentives to retire while healthy. That's one of the reasons why there's not so much need for term-limiting lower court judges. One more reason to regularize Supreme Court nominations to 2 per presidential term is to minimize the chance of dramatic shifts in the Supreme Court's ideological direction based on such happenstances as the outcome of the very close 2016 election. If President Trump wins a second term, he may well end up replacing Justice Ginsburg, now 86, Breyer, now 81, as well as the late Justice Antonin Scalia and retired Justice Anthony Kennedy, likely entrenching a strong conservative majority for a generation to come. Now that might sit well with many in this room, but how would you have liked it if Hillary Clinton had won in 2016 and were to win again in 2020? That would have left the court with 6 solidly liberal justices. The risk of sudden big lurches to the ideological left and right will be substantial for as long as the justices serve for life. Thank you.
Ms. Severino?
Thank you so much. My apologies in advance for my sore throat here. My husband commented this morning that I look a lot like a flight attendant today. I'm not actually planning on switching careers. I'm just trying to keep my throat in as good condition as possible. Tea and warmth. So calls for change to the life tenure process in the courts have been coming for almost as long as we have had federal courts. The earliest that I found, but there may be earlier, was in 1807 when Thomas Jefferson himself started calling for an end to life tenure on the court. So this is certainly nothing new. But I do think before we jump into the idea of changing it, as we should with anything, I mean, I guess being good conservatives in this sense, you should always figure out why was it there in the first place. G.K. Chesterton said, when you find a gate across a road or a wall as you're walking through somewhere, your first instinct shouldn't be just to tear it down because I don't know why it's here. He said, go home, think about it, figure out why someone put it there, and then you can come back. And if you can tell me you know why it's there in the first place, then I'll listen to you if you tell me to take it down. So I think first of all, the question is, what were the framers doing here? We talked a lot about judicial independence, and the question is, were they either wrong in some of those assumptions, maybe it didn't work as they intended, or have times, in fact, changed in a way that life tenure isn't as necessary for judicial independence as it once was? I'll point out that this was, they felt life tenure was so important for the independence of the judiciary. This was actually literally mentioned in the Declaration of Independence. The fact that judges were dependent on the will of the crown for their tenure of their offices was something that our framers took exception to. So obviously the alternative isn't simply at the will of the president, but this was something they felt very deeply. So some of the assumptions they had were, first of all, they wanted to be, they expected that judges maybe wouldn't have served as long. Life tenure, of course, was only in the around age 40 when, at the time of the Declaration of Independence and the Constitution. So maybe they thought people wouldn't serve as long. However, that was something that actually was contemplated in Federalist 79. Hamilton points out that having age limits on judges can be very pernicious. It would have eliminated people like Benjamin Franklin, who was 81, from participating in the constitutional conventions, and lists other Lord Mansfield and other illustrious jurists. So they realized that not everyone's going to make it to that age. That was twice life expectancy, but that those who did might actually still be able to serve very well. At the time, of course, the problem was not people staying too long, but people leaving too early. You have people who serving as few as 4 months in the early republic, and part of it was due to the rigors of riding circuit and travel. There were many justices, actually, whose lives were shortened because of the difficulty of traveling through the early republic to do their job in terms of riding circuit. So a lot of things have been addressed, taking out the riding circuit. Now we have air travel that makes that so much easier. There's also things like having clerks, having, Lexis and Westlaw at our fingertips. The job has been made much easier to stay in longer, so you don't have people immediately leaving. There's not the temptation, for example, to leave for elected office that perhaps there once was. John Jay himself left because he felt like the court hadn't yet achieved the strength that he thought it should and the prestige. He said, I can do more good as governor of New York. That probably isn't going to happen today. So maybe there are some reasons people are going to stay a little longer than they thought. One of the other assumptions of the framers was that life tenure would be very important because judges, as Hamilton put it in Federalist 78, were the least dangerous branch because, as he said, if they exercise judgment, not will, they don't have the authority to make laws. But they also warned that if the judges were to have that power joined to the judicial power, that it would be very pernicious to have judges in life tenure. So I think we can query whether that has happened and whether we need to worry about judges having life tenure specifically because, as several people have mentioned, it's become a very political role, unfortunately. So there are some of these things that I think the final thought is judges assume this would, the framers assume this would increase the independence of judges because they won't have to look for their next job, and I think that's absolutely correct. But I think we have learned that there is still risks that judges are going to look for outside influences, whether it's the adulation of the media or some worry about the cocktail circuit, the greenhouse effect. A lot has been written and spoken on this, so to the extent that those things are motivating factors to judges, maybe life tenure is in fact not even enough to ensure the independence of the judiciary. So there are some things that have changed, and maybe it's time in terms of the what has changed on the ground in America to say, well, so we can address the independence through other means and not through life tenure. But I think a bigger question also needs to be asked, and that is, what are we hoping to accomplish, and would changing from life tenure actually accomplish that? We heard a lot of people talking about things like judges being appointed too young, and this is going to expand the field. I think, say you have 18-year terms, it may expand the field up to the age of 60, but I find it hard to believe that any president is still going to want to appoint someone who is old enough that they are going to be serving that necessarily a large portion of their limited term is going to be in that age. I think you still have an incentive to appoint people young, but there are natural checks in the process of appointing people too young. They function now. No 20-year-olds are being appointed to the Supreme Court because apart from having to convince senators that they're qualified, presidents actually want to know what the judicial philosophy of their nominees is. And so there is going to be a natural floor in terms of the age on that. I'm not sure adding terms is going to increase that significantly. In terms of judges staying past their prime, this may address some of that, but at the same time, you end up cutting off the Ben Franklins, the Lord Mansfields of the world, who actually can function very well in their older years. And so we have to recognize it's going to happen on both ends of the spectrum, so it's going to cut off some people. And I think it's also worth adding that in today's world, where we're literally considering electing someone who's 78 years old and just had a heart attack to be the president of the United States, not to mention all of the other septuagenarians who are running for office, if the American people seem to think these people can carry on not only the rigors of a campaign, but also the presidency, which I would submit is significantly more physically, if not mentally, rigorous than the Supreme Court, we might be a little presumptuous if we're saying, well, we know that judges can't serve past a certain age. And then I think finally, which seems to be the dominant reason here, is judges are acting too politically in the way that they retire. Maybe people are retiring for political reasons. I agree with Judge Strauss. It's hard to prove that happened. You have evidence even that people have tried to retire for political or not retire for political reasons. It doesn't always work out. Thurgood Marshall is said to have told his clerks, if I die, just prop me up and keep on voting. But ultimately, he retired during George Bush's presidency. So he ultimately, that caught up, his actual physical health caught up to him. He said he was falling apart, and he did retire. So people are still, that doesn't necessarily work in a large number of cases. And remember, there are two types of political retirements. There are people who stay on past their prime. That, I think we should be concerned about making sure that people aren't judging past their prime. However, there are also people who retire early for political reasons. Say your term ends in what will be the first year of the next presidency. Maybe you retire a little bit early. I'm not aware that their system would require people to serve their full 18-year terms, but I'm certain that there's still room for political strategic behavior in terms of retirement. But finally, I think when it comes to the politics of the confirmation process, we have to really be skeptical about the idea that changing to term limits or to age limits would actually fix things. The reason Supreme Court confirmations are so contentious is not because of the timing of judges retiring, and it's not more than, I think, a marginal difference because they serve life tenure, because 18 years would still be a huge impact. I think it's because judges more and more are doing exactly what Hamilton feared. They're uniting the legislative powers into the judicial power, and as long as they are functioning both those roles, they are a very dangerous branch. So there may be good reasons to move from life tenure to different system, but we can't expect that to change the confirmation process. As long as judges are having political impacts like this, we're going to see a politicized confirmation process.
Okay. Let me first ask the panelists if there are any things they would like to say to each other.
Yeah. Just a couple of comments regarding some of the things Judge Strauss said. One, on your term as an elected judge, and we could have a whole other panel on whether we should have elected judges, compared to having life tenure now. I think that's apples and oranges. An 18-year term is a lot different than serving as an elected judge. And also, in terms of moving to another office, so if you're a Supreme Court justice and you're there for 18 years, I cannot imagine a single example of somebody 16 years in who would worry about whether there would be another job available regardless of how you voted. And in terms of moving to an executive office or another office, there's nothing that prevents them from doing it now, leaving their life tenure to do that. That would be the case with a single 18-year term. And finally, in terms of the temperature, I do not believe that we would have a huge difference in temperature for an appointment for the 18-year term, although it might be a little bit if we create the sense that every president has the ability to pick 2 justices during that term. But where it may make a difference is if somebody leaves either voluntarily or for other reasons, and then there's 4, 5, 6 years left in the term, or maybe even 1 year left in the term. Let's say that we had this in application when Justice Scalia died. And let's say there were 4 years left in that term. The way in which I think the Senate and maybe the country would have looked at that position, if it weren't now picking somebody who might serve for another 40 years, but simply for the remainder of that term, it might have changed the way the Senate looked at it when Barack Obama was president, and it might have changed the way they looked at the Gorsuch hearings if that was to fill a much shorter term. So I think it could make a difference, although not a huge one.
Yeah, just to respond, I agree with you that it is somewhat apples and oranges to compare a 6-year term with elections to an 18-year term. I would say, though, that an 18-year non-renewable term is somewhere in between, right? It's not a 6-year real short term, but it's also not life tenure. And so I think that where that balance is struck, I don't know, but I do think that there's value over life tenure versus an 18-year term. And when I'm talking about sort of the final period problem, I really highly doubt that justices, and maybe I'm wrong about this, some justices would, but that most justices would be happy being rotated off after 18 years. And what I'm thinking is they may want to do something different. Rather than starting to sit on the lower courts, the circuit courts and the district courts, they may want to become ambassador of the United Nations or something. And there's been examples of justices that have gone on to do that. And I think that creates an issue about how they behave in the last couple of years.
Well, one, I would love to have people distinguished in that way moving on to other offices, but that's their choice. The point here is you could preserve the idea of life tenure on the courts without requiring a constitutional amendment. If they wanted to stay, fine. If they wanted to leave and do something else, what a great pool of people to have in other areas of public life or private life.
Sure.
If I could just address the question of filling out uncompleted terms, I think you just have to balance the idea of maybe everyone would view that, say, a hypothetical 4 years left in Scalia's term or something that had to be filled. Recall also that there are nominees on the other side. In what are you going, when you have a potential for the type of confirmation process we have seen, and I unfortunately don't think it will be that much lowered in temperature, how difficult is it going to get our best and brightest to step up when they know they're going to have a 4-year non-renewable term to fill out? Who is going to step up for that seat? Or do you allow them, if they've served a short enough time, to have a subsequent term? I think that creates a very sticky problem in and of itself.
Oh, I see no problem at all with saying if somebody fills out the remainder of a term, just as we have with term limits for presidents, if you serve for less than the 2 years of a remainder of a term, you are then eligible to be elected twice, that you could then be eligible to be chosen by another president to serve an additional 18-year term. No problem.
Go through an additional wonderful confirmation process. It just might be harder to recruit nominees is my concern.
Any others want to react?
Well, I might just throw in one caveat about, if I understood Norm correctly, I don't much like the idea of a term-limited justice being appointed to a 4-year term and then hoping that whoever is president at the end of that term will keep him.
Oh, I'm not suggesting that it would then be that you want to necessarily have the same vacancy.
Yeah.
Just that at a subsequent point after that, you're eligible if another president wants to choose you. Could be for a completely different seat.
Well, on this constitutional impediment, I wonder about this. If you think that there's not a constitutional problem with having a Supreme Court justice after this fixed term then serve in another judicial office, if that is true, then why doesn't it work always? So that would mean, would it not, that through ordinary legislation, Congress could enable the president to move district judges to appellate courts or district or appellate judges to the Supreme Court without a new confirmation. Is that right? If you can move them down, why can't you move them up?
I'm not sure about. I don't think
Might be a problem.
Yeah, I don't think that would be the case. But I'm also perfectly happy if that turns out to be a problem to simply move to senior status. And of course, what we have now is retired Supreme Court justices on senior status who often sit on appeals courts or do other activities in the judicial arena. Do it that way and avoid the problem.
Now, one of the points Dr. Ornstein makes, Kerry, that you say, well, once you get past 60, if it's an 18-year term, you know, it really doesn't change the dynamic. But, I mean, what if they're in their late 50s? I'm asking for a friend.
Well, again, I don't think that it may expand very marginally the age range considered, but 18, I still suspect you're not going to have someone who says, this guy's already, 65, but he's good for at least 18 more years. And we have had people who have served 18 years past that age, but it's still, if that's a strategic analysis, it's still going to be made whether you have an 18-year term or a life tenure.
David, I don't know, my next job, I want to be ambassador to the Vatican.
There you go.
Now, I can't help interjecting a point in favor of life tenure. Oliver Wendell Holmes Jr. was 90 and had 28 years on the court under his belt when at the sight of a pretty girl he exclaimed, "Oh, to be 70 again."
I'm not sure if I would have regarded Holmes as the way to persuade this crowd. Okay, we're now to the point of the program where we can take questions from the audience. Do we have microphones that are going to be available? Maybe not. I have one reminder about questions. It's my usual caveat when I moderate a panel. We have panelists who are invited to be our panelists. All the rest of us have different roles. So there aren't any other panelists, but we do welcome questions, so long as you keep them to questions. I understand that sometimes a question needs a little bit of a setup, but please keep in mind that what we are opening this up to are questions. And the first hand I see is Professor Soman. I'm not sure which Ilya you are. Are you good Ilya or bad Ilya? Professor Soman.
Yeah, thank you. So for those who don't know, I'm Ilya Soman of George Mason University. I'm a law professor. There's also another Ilya Shapiro, who works for the Cato Institute. I'm asking the question purely on my behalf, not that of all Ilyas everywhere. I'm quite sympathetic to the idea of an 18-year term limit for Supreme Court justices, but I wonder if I might ask about a potentially troubling implication of the idea that this can just be done without a constitutional amendment. That the theory that was offered today is, well, they will still be judges serving for life, but they can just be moved to a different court. If that can be done just by ordinary legislation, would Congress then not have the power of just passing a law saying, we don't like the recent set of decisions these particular Supreme Court justices have made, so we're going to move them off the Supreme Court. They can still be federal judges, but they got to be, serving on federal traffic court in the middle of the Western tundra or something. Even if they can take senior status and still live in their comfortable lifestyle in Washington, D.C., that still strikes me as a potential threat to judicial independence for obvious reasons. So I wonder, is there any way to avoid that? It would seem to me that implication of the argument.
So I would say I see that as along the same lines of basically saying, we don't like this Supreme Court, so we're going to increase its size by 3, 4, or 5. You can do that legislatively, obviously. The court started with 5 and moved to 9. We have pretty strong norms that have prevented that from happening, and I think you have the same norms that would apply. And if those norms didn't apply, the first thing they're likely to do is just increase the size of the court.
I might add, 18 years is not something that can be politically manipulated. We would like to get rid of these justices now, obviously can be politically manipulated.
Any others?
I'll just point out it's another evidence that this probably isn't a constitutionally available option, because there have been lots of times, as I mentioned Thomas Jefferson in the beginning, where they were just desperate to get rid of people on the Supreme Court, and the fact that it hasn't been tried yet suggests that maybe no one ever thought it was really an option. So change a way, but do it with a constitutional amendment.
Yeah, and just to add to that, I think it was between 1805 and 1807, that happened 3 times. Thomas Jefferson tried to change life tenure, and each time the proposal was by constitutional amendment, not by statute.
By the way, there is, I see now, a microphone here and over here. So if you will, please go to the mic so that everyone can hear your question. Yes, sir.
So question is, I'm struggling with this scenario where we have a Supreme Court justice who's maybe filled the remainder of a term, maybe 4 or 5 years, and then they come before the Senate Judiciary Committee to be appointed for a full 18-year term. I'd love the panel to address the pros and cons of a scenario where a Supreme Court justice who has 4 or 5 years of decisions is getting questions from either side of the ends of the spectrum to justify those decisions that the court as a whole has made. I think that seems problematic, but pros and cons.
I would just say we get the same dynamic now with people who've served on courts of appeals for periods of time and have to justify the decisions they've made or the decisions made by their courts. So I just don't see a huge difference there, and including a difference in the way that a nominee would address those issues.
I feel a little bit differently. I don't like the idea of somebody serving 2 or 3 or 4 years and then having to try and get reconfirmed. And I think the solution to that is for any new justice gets 18 years, no matter how much was left in the term of the person he or she succeeds.
With the challenge, of course, the problem is it's a very complicated thing to do. If you do that, then the beautiful balance of bipartisanness or alternating presidents is going to get thrown off. And then there's also these weird long-term impacts of almost inevitably you're going to have some strategic early retirements there, and so it's going to throw the whole system off. So you could have someone who goes into their presidency knowing that unless someone retires off of their term, they would never get a Supreme Court vacancy. So it's complicated.
Of course, there was a time when recess appointees sometimes served for a while before they were confirmed. I mean, Justice Brennan, for example.
There was a time when that was actually a very successful strategy to getting confirmed, which actually raises some of the same concerns about having a short term and then being confirmed, because that's happened historically on a regular basis.
Question over here on this side.
Hello. I have a two-part question for the entire panel. Okay. I would like to know what you think of the following constitutional amendment proposal, and whether you think it would enjoy popular support to get actually into the Constitution. It seems to me what we're trying to do is limit the reign of judges because you feel that justices stay on too long. So we could look to the other two branches of government. To serve in the House of Representatives, we have a minimum age of 25, U.S. Senate 30, for President 35. If we're interested in limiting to, say, 18 years, we could reverse engineer a minimum age, say 70. It would preserve the current system of like life tenure, but you would obviously limit the terms based on, you know, the minimum age of 70 or 75.
Got new life.
I like it.
Anybody?
Well, one problem with that is, and we highlight this in the article I wrote about 13, 14 years ago, is when you start talking about mandatory retirement ages, which is sort of the flip side of your proposal, which is a minimum age, it's both under-inclusive and over-inclusive. I agree with Stuart, for example, that there are well-documented cases of mental and physical infirmity, not so much recently, but over the entire course of American history, where justices were not able to do their job, and judges were not able to do their job in the lower court. The problem is it's correlated with age, but you can't precisely figure out the time in which a judge is going to become infirm. So if you have a minimum age of 7, you may well be putting somebody who's going to, you know, end up with dementia 3 years down the road. And so that's not necessarily a great fix either.
Any others? Is that you, Professor McGinnis?
Yes, John McGinnis from Northwestern Law School. So I do think it's a very hard issue, but I wonder whether this would be
Could you speak closer to the microphone?
Yes. I do think it's a very hard issue, but I think I would like to ask about this possible downside of an 18-year term limit, which is that it might make the court actually more political rather than less, in the sense that a president is going to choose a justice with a great regard to the issue mix of the day, and therefore will be directing the judges sort of politically. Over time, issue mixes in politics change, and so you might well think that a judge who's there at 25 years or 30 years is less likely to be judging politically, but on some other basis. And we actually have examples of that in American history. The FDR was very concerned about the power of Congress and appointed judges who sort of all agreed on that and made a political change. But as they got older, they disagreed on questions of rights because that wasn't in the contemplation of the president.
I'm skeptical. I'm skeptical about whether, for example, now we don't have those political considerations in the minds of presidents, but also whether in our world now we're going to see dramatic changes in the way judges or justices look at the world. And if they're going to do that. We may see it emerge before the 18-year term, but I think we're not as likely to see that. And if the world changes, then after 18 years, you're going to have a different context to choose another kind of justice.
I think there are problems, downsides to the 18-year term, and that's one of them, but it's pretty far down the list, I think. I'm not very worried that presidents are going to be thinking more than 18 years down the road when they're deciding who they want to appoint to the Supreme Court. Maybe there's somebody somewhere who would be thinking that way, but I can't think of any recent president who would have.
Anyone else? This side?
So it seems like there's a split on the panel on it being a problem that there's the length of terms that we have today and the somewhat random nature of how they get filled. There's also this problem that's been alluded to about court packing and what if we change the number of members on the court, and that could be done by ordinary legislation. Do you think there's a grand coalition out there for going to some kind of 18-year system, but at the same time putting in the Constitution that that there's a 9-justice limit? And would some of you maybe change what you think of what you've said already on the panel if we could make that coalition, that compromise come about? Or do you think it's a good idea at all?
Well, I think one of the challenges with this in general is that so many times the clamor for changing something tends to follow the political trends. So, I mean, the fact that Jefferson was trying to change the Supreme Court had everything to do with the fact that he wanted to get rid of Samuel Chase and others who were opposed to him on the court. It wasn't necessarily a broad, high-minded, I'm thinking this isn't working for the court in general. And that unfortunately happens overall. So I think if there were to be a successful move to go to whatever type of 18-year thing, it would have to be done in a way that it was phased in so that it didn't have any predictable impact on one political side of the spectrum or another. I think that's going to be the real challenge, and maybe tying it with another, anti-court packing strategy would be the thing. But I think trying to make it a nonpartisan enough issue that you could get the overwhelming support to have a constitutional amendment is the challenge, and that's one strategy.
The other point I would make is, when you start tinkering with the Constitution, and particularly the structural parts of the Constitution, I wonder whether the cure is worse than the disease, and that there's a lot of unintended consequences that could come about that, even though I wrote on this subject and studied it for a while, I may have missed things, right? And so I don't know what it would do to our constitutional republic. And so I worry, without a compelling case for changing it, whether we should be tinkering.
Anyone else?
I would just suggest the possibility that the urge to tinker might be assuaged somewhat by going to 18-year term limits and take some of the energy away from the court packing urge to tinker. Yes.
Agreed.
Here. Yes.
Hi, my name is Vishru Chilad. I'm a 3L from Vermont Law School, and I just wanted to ask you guys what you thought about a compromise system where we kept the lifetime tenure, but we introduced a provision in the Constitution, through a constitutional amendment, of course, that allows the president to nominate a new Supreme Court justice every 4 or 8 years, depending on popular support, if they feel like the justices that are currently appointed aren't doing a good enough job. And then, of course, the Senate and the House confirms that nomination. What do you think are the pros and cons of such a compromise where we keep the tenure system, the lifetime tenure system, but we also have a provision that allows an easier process for the executive and the legislative branches to replace justices too? Thank you.
I'd be a skeptic of that, partly because you could have significant periods where you have an even number on the court, which could mean deadlocks and many decisions. But you could also then end up with a very, very large court. So I'm not sure that's a direction I'd want to go in.
Yes, ma'am.
Hi, Judge.
Hey, Krista.
Quick question, primarily for Judge Strauss. Does the separate offices idea mean that the current process of sitting by designation is constitutionally suspect, at least across courts?
I think the answer is no, and this gets back to what your primary responsibilities are. If you are a circuit court judge, for example, sitting as a district court judge, or even a Supreme Court justice. There's a famous example where Chief Justice Rehnquist sat by designation in the Eastern District of Virginia and then ended up promptly getting reversed by the Fourth Circuit. I think that's fine because you're still carrying out the duties of your office. Where it becomes iffy is where after 18 years, you're now effectively in a different office entirely. And therefore, that's where the separate offices reading, I think, really comes in.
Well, and that's really supported, isn't it, by the fact that at the founding, Supreme Court justices rode circuit.
Right.
Right?
Which was the equivalent of designation, sort of.
Yeah, the equivalent.
Except for there weren't no circuit justices, right? It was the district judge and then 2 Supreme Court justices were the circuit court.
Right.
So that was
Right.
actually part of the requirement of the job initially.
Right. But it was the definition of the office.
Right.
Question from the middle.
Yes, my name is Joe Brannigan. I'm a Superior Court judge out in San Diego, California. I was elected in 2004 and have run for re-election every 6 years. Recently, a judge up in Northern California was recalled after a controversial decision, followed the probation officer's recommendation, and gave probation to a young man from Stanford that had, a swimmer, I think, for the swimming team, had been charged with sexual assault, convicted, pled guilty, actually. So I guess my question for the panel is, there's a real-life example of what judges who are up for re-election every 6 years have to consider, and I'm with the judge here that said that you put
So
that
is there a
out of your mind.
question, or is this a...
Yeah, the question is
presentation?
just what the panel thinks of a real-life case like that. Does that have any effect on their position?
I happen to believe electing judges is an abomination, that it gets directly into the political arena, and I think your case, that example is a good one. It's also what we've seen in many instances where you have judges running for election who feel they have to pander to political judgments out in the country, and then there are questions of campaign contributions, where they come from and how they're raised. So to me, that is a good example about why we shouldn't have elected judges, but it has nothing to do with a single 18-year term for a Supreme Court justice.
Well,
Go ahead.
Oh, just to follow up on that, I mean, really depends on what you want from your judges, right? So elections work, and I disagree. I think that elections are perfectly legitimate, particularly like in Minnesota, where there was a long history of elections, and it was, in the Constitution that you have to stand for election as a judge. But you get a politically responsive court. That's the result, or a more politically responsive court overall, even if not every individual member is necessarily affected by having to stand for election. If you want a politically insulated court system where judges can just decide it based and ignore all the noise out there, then life tenure would be the better system for that. So it kind of just depends on what you want. And as I said earlier, I think 18-year non-renewable terms are somewhere in between.
I mean, doesn't that really strike, though, at what is the meaning of judicial independence? That is, independence from what? Is it independence from the people, or is it meant as independence from the other branches? Do you have a perspective about that?
We just heard some lectures from Professor Gordon Wood on the subject, and he said one of the unintended consequences of Hamilton's claim that judges were really the agents of the people, just like members of Congress were agents of the people and the president was an agent of the people, is that it became natural, even though not welcome from Hamilton's perspective, it was natural then to argue that as agents of the people, the sovereign people, it was appropriate then to elect the judges and not have them appointed in this indirect way that we've now inherited. There's a lot of evidence, political science evidence, that suggests that in the run-up to elections, the behavior of judges change. The political scientists have focused mostly on changing vote patterns in criminal cases. And the evidence suggests that fear from the political process does induce a tougher on crime voting pattern among state judges standing for office. So there's
But
another
would the
fact.
founders have understood
Right.
independence to be independence from the public, or did Hamilton's formulation really suggest that what they were concerned with was independence from the other branches?
It's structurally, I think, in terms of the other branches. I agree with you.
I just point out Joseph's story actually talked about it in terms of both. And he said you have to have judges who are going to be independent, because sometimes making the right decision is also going to make you very unpopular. So it goes both ways.
But also, I think the idea of electing federal judges wasn't even part of the conversation at the time,
Right.
was it?
No.
And so I think that suggests that they wanted independence from the people as well as from the other branches.
I think it was done in many states early on, so it's hard to know.
So, next question.
Hi, Rob Chatfield, Free to Choose Network. I've heard a couple of people advocate for each president being able to nominate two, but nobody talked about when in their term they would do the nomination, beginning, middle, end of term.
Well, you stagger these, obviously, and we phase it in as justices leave. So I think it probably is not necessarily going to be everyone comes right at the beginning or the end of a term. It's going to be somewhere perhaps in between. Now, if you started from scratch, you'd probably want to have either both at the beginning of a term or one at the beginning and one 2 years in. But we're not starting from scratch.
Heather? Next question.
Given what we've seen of the legislature, what does this kind of proposal mean for the legislative function? We're turning the legislature into electors of the Supreme Court, which shall govern us. That's a conundrum posed to you.
I honestly don't see any difference from what we have now. You're still going to have a confirmation process that's comparable to what we have now. Just it'll be on a somewhat more regular basis.
Yes, question.
Hi, I'm Olivia O'Sullivan from the Federalist Society, and I'm just asking, what role do you think seniority plays on the dynamics of the Supreme Court, and would that be lost or enhanced with the implementation of 18-year term limits?
Have any thoughts about that?
I doubt that seniority has a very big effect on the workings of the court, and therefore, although this would obviously skew who has more seniority, I doubt that would have a very important effect.
I do think that one thing that it would do, and whether you view this as good or bad, I'm going to leave that to all of you, but a number of justices, I think Justice Kagan said this most recently, that every time you add a new member of the court, it changes the court, it makes a new court. And so if you're changing the court every 2 years, that is not the seniority part, but that's going to fundamentally change the dynamics of how the court functions. Now, whether you think that's a good thing or a bad thing, I'll leave that to you, but I do think it's an important consideration.
If you walk out to the hall, please try to do it quickly. That is a distraction. Yes, sir.
Hi, my name's Dave. I'm a law clerk to Judge Strauss, so I'm biased in some ways, but
and nervous.
A little bit. I don't want to embarrass him, so my question is, I guess
you already have.
Fair enough. So I guess the opposite of retrenching new majorities and having a long influence on the court is constant shifts. So if every 2 years you're changing the composition of the court, you're also potentially changing controversial decisions. And I wondered if people thought that was a good or bad thing, or if they disagreed that that would be an issue at all.
We have fairly frequent changes in the court now. Partly what I would hope would happen is that if you get 18-year terms, that means that in some ways you're getting a little bit closer to what voters in general think, that the changes are going to be fairly gradual, but they're going to be ones that will be more reflective of where we are as a country at the time that these changes take place than what we have now. And what I see happening now, you're right, we're not getting 20-year-olds nominated, but the trend is moving downward. We're likely to get, and we're seeing now nominations for appeals courts of people in their early to mid-30s. I'm not sure that's a very good thing. I suspect the tendency as we move to even more partisan and tribal times is going to be to try to extend your influence in the political arena as long as you possibly can after voters have decided they wanted to move in a different direction. So it's going to be even more highly charged, and I'm just not sure that seeing these changes that happen with, as a president is able to pick 2, where now some may be able to pick 4, which can even more radically change the temperature on the court, would be a huge deal, or worse than what we have.
I'm not, it may be in a micro sense, there is a trend downward in terms of the age, but I think if you look at it more broadly historically, there were 30-somethings being appointed in some of the early years of the Republic. It is not, you know, this would be, I find it hard to imagine that nowadays you would get someone confirmed under age 40. I think it was shocking, even age 43, where you've got someone like Justice Marshall, who I think was 46 when he was nominated and served for 34 years. He was young when he was nominated, he served for a long time. This is very early on, so I don't think that's anything that's new. To the
30s in the early 1800s was a whole lot different than 30s now.
Yes, I know it's closer to the average age things, but it's, again, once you got to a certain point, like if you were 60, it was actually fairly likely you were going to make it to 80. I think there's a lot of challenging things about figuring out about those numbers. Just pointing out that, you know, this is not something that is the first time in history would have happened, and I don't think 30-something appointments is likely to happen anytime in the near future.
Dave, to get back to your original point, though, I want to just point out, I think that the answer to your question is yes. And I'm going to go back to state courts again, where state courts, the turnover tends to be very rapid on courts of last resort as compared to the Supreme Court. I mean, it may not be rapid by other professions' standards. And what you see is you start changing a member or 2 on a state Supreme Court, and it radically changes the types of decisions you see from that court. Sometimes overruling, sometimes not overruling prior cases, but driving away from them or moving away from them. And so I do think, you know, I'd love to be able to run a controlled experiment. We don't know. That's the academic in me, but I have to believe that just simply changing the membership based on what members of the court have said about how it changes the court will lead to more rapid changes in the law.
It's a nice rescue of your law clerk there. Yes.
Hi, I'm Michael Thompson. I'm at 2L Yale Law School. It seems like there's a kind of a hopefulness that this will add some sort of political stabilization by like offsetting these different nomination terms. But what's going to make the Senate play ball and actually confirm or deny these nominations?
So what makes the Senate play ball now? And the answer is it's very, very difficult. But I think you could actually make a case that this would be easier. If you know that it is the right of a president, of every president, you've got 2 slots, not just one that happens because somebody drops dead or somebody even strategically leaves to try and give you additional leverage. There's a little more legitimacy in that, in pushing the Senate to at least hold confirmation hearings and maybe to give a president a little more slack in terms of the kinds of nominees that would be accepted by a wider range of members of the Senate.
But would your proposal prevent a Senate from holding it open
You cannot,
until after the election?
No, you can't do that any more than you can now. And so, you know, we know that Senator McConnell mused that if Hillary Clinton had been elected, he wouldn't let anybody fill a vacancy on the court. That's the reality of where we are now. That's, if we're able to change it, we can change it at the margins by giving it a little more legitimacy, which is what I believe in.
Yes, sir.
Michael Bushbacher. The Chief Justice plays a very important role in shaping not only how the court presents itself to the rest of the world, but how the court goes about its business. My question is primarily to the reformists. How is the Chief Justiceship going to be allocated in this system? And what are the things that are going to be in place to ensure that, because it seems like it's an area for potential gamesmanship. I get it, it's a marginal change, not a fundamental change, but I'm just curious for your thoughts on that.
You know, of course, what we have now is, thanks to the luck of the draw, a president can pick a Chief Justice, and that Chief Justice can serve for many, many decades. And another reason, I think, for an incentive, even more of an incentive to, when you have a vacancy in the Chief Justice's position, to pick somebody who tilts younger now. But you'd just have that position just like any other, would be an 18-year position.
As long as you're amending the Constitution, you could also decide to change it where it's like a senior judge type thing. It's
Yeah.
the most senior one. Yeah,
Sure.
I believe you'd have to
Yeah.
amend the Constitution anyway, so there is flexibility.
Yeah.
Okay, next question.
Owen Smitherman, Boston Consulting Group.
You didn't get to move closer to the mic.
Owen Smitherman, Boston Consulting Group. My question is about taking a cue from an earlier questioner. How do you get the existing justices to play ball so that they retire in the right way to set up all the 18-year 2, right? Is that going to be through statute, some kind of pressure? Otherwise, you're going to get all this weird, 3 years, 2 years, 5 years, 1, and that kind of defeats the purpose of evenly spacing it out every 2 years.
Yeah. Well, I think this is something that is going to take place over a very, very long period of time. We're not going to have it happen overnight, and it's going to have some dislocations. But I don't think you force people to retire early or even urge them to retire early. You move as people move off the court and then try and frame it with the timing so that you end up with, over a long period of time, the 18-year term staggered for 2, but it'll take a long time.
All right, last question, and then final statements from panelists.
Bob Manchin, student at George Mason.
I can't hear you.
I'm Bob Manchin. I'm a student at George Mason. Some of you have addressed the contentiousness aspect of the confirmation process, but I have a question about another aspect of the confirmation process, and that is this dance that people, especially from Republican nominees, are expected to do around policy issues or politically charged issues, sort of answering questions, trying to answer questions without really answering questions. How do you anticipate this presumption that there will be 2 years or 2 picks per president to affect that dynamic in confirmation hearings?
I'm not sure it changes much at all. I will, I actually really liked the time in the past when we had justices who had much more varied backgrounds. A majority of members of the Supreme Court had served in an elective office when Brown v. Board of Education was decided. I think it made a significant difference. I'd love to get people who've had a range of life experiences. We now live in an era where presidents don't want to pick justices who might change over the course of their tenure, or where they are not pretty certain about where they fall on issues that they and their parties care about. So it's a dance that happens during the pre-nomination process. It's why we now almost exclusively look to appeals courts for people who've served for a period of time, so you're pretty damn sure where they're going to go. I don't like that, but that's the world we live in, and I don't see that structural change is necessarily going to change that. We hope over a longer period of time, maybe we move to a different era.
Any final thoughts from any of our panelists?
One speculative thought. The proposal, the 18-year terms and all that, has lots of complicated imperfections, as has been pointed out. One thing it might do, for better or for worse, is increase the leverage of the Senate in the picking of Supreme Court justices, because if the presidents collectively are going to have to do it more times, and every time they have to do it, they're going to have to get it through the Senate, that could increase Senate leverage over time. And that might be a force for moderation, frankly, I think, which I would like and a lot of other people would not like.
Yeah.
Just a quick comment on the power of the Chief Justice. The power of the Chief to appoint is not necessarily constitutionally conferred or compelled. The fact that the appointment power is vested in courts and not in judges suggests that you could make a change there, and that change wouldn't require constitutional amendments, and therefore a decision to stagger Chief Justices wouldn't necessarily upset settled assumptions about the power of the Chief. If the power were reclaimed by the court, then it would seem like less of a political consideration that would be a basis for retaining a party affiliation for a particular chief.
Okay, please join me in thanking our panel.